So here, the sources of obligation is under 1157. So this is, in other words, the juridical tie, which I was been talking about. No, juridical tie. The first juridical tie is the law. So it must be expressly or impliedly set forth and not presumed. So there must be a law. So example, payment of taxes on or before April 15. No. So one is if a taxpayer earns or an individual earns an income, he is compliant to pay income taxes. And that is on or before April 15. Is the law clear? Yes, it's very clear. Does it prescribe? Yes, in 10 years. No? What is prescribed? It's like expiration. It's a prescription. So prescription or prescribe meaning the action to file or to file a claim against that person is already expired. So after 10 years, if the state or the BIR will not file a complaint or claim that this person has not been paying taxes, has already lapsed for more than 10 years or 10 years to be exact, then it is already expired or prescribed. No? So the law prescribed in 10 years. Another source or juridical tie of an obligation, contracts. This has been explained already in the example. The contracts are agreement between individuals which must be complied with good faith. So provisions should be legal. Otherwise, parties cannot enforce them. Contracts will be discussed later after the midterms. So is there a prescription? Also 10 years, no? If it is in writing. If the contract is oral, it prescribes in 6 years. So the action to file a claim will expire in 6 years. So remember this prescription periods, no? If in writing, if the contract is in writing, then 10 years. If it is only a contract orally or expressly made, then the prescription is 6 years. Quasi contracts. Is there a prescription? Yes, 6 years. So there are two kinds of quasi contracts. The first is negotiorum hestio, also known as unauthorized management. This happens when a person voluntarily manages an abandoned property or business belonging to another without the consent of the owner. So example, Elliot's neighbor was in Baguio having a summer vacation. So there's nobody at home. So during that time, the neighbor's garage was burning. No? There was a fire. But Elliot was able to put out the fire timely and save the house from burning. So in this case, the owner of the house is the one who is obliged to pay Elliot for his effort. No? Was there an agreement between the two of them? There was none. No? The Elliot made his efforts were timely made in order to save the house, and it was voluntary on his part. There was no agreement between the two of them. So this is a case of negotiorum hestio. So this is called quasi contract. So if ever Elliot has been injured during that saving act of putting out the fire, then the neighbor will be liable to pay for his medical bills, no? Bayad sa tambal. Another example of quasi-contract is solutio indebiti. This is what you call undue payment. So this happens when a person unduly delivers a thing through mistake to another person who has no right to demand it. No? So example, Chip went abroad to work. Upon saving enough money, he deposited 100,000 to his parents' bank account here in Cebu. So he called up his parents and informed them of the news. There was a deposit made of 100,000 pesos. So the Chip's parents went to the bank and inquired on the balance of their bank account. To their surprise, the deposit made in their bank account was not 100,000 but 1 million pesos. So there was a mistake on the part of the bank. No? The bank committed an error by entering 1 million instead of 100,000 pesos. What happened in this case, this is an actual case, instead of correcting the error, parent of Chip or his dad withdrew all his money, all the money, withdrew the 1 million pesos. So upon returning here in the Philippines, Chip's parents were imprisoned. No, they were sent to jail. It's a case of estafa. There was fraud on the part of the parents of Chip. They were not honest. So estafa na. So the principle behind solusyo in debate is here, that no one should unjustly enrich himself at the expense of another. So you should not enrich yourself at the expense of another person. The fourth juridical tie is delict. Delict is also another word for crime. This is found in Article 1161. Now, crimes are in the Article 100 of the Revised Penal Code. It says that every person criminally liable for a felony or a crime is also civilly liable. So he cannot only be sent to jail, to the ilang priso, but he's also civilly liable. So what are his liabilities? So these are his liabilities, no? Restitution or restoration. He must restore or restitute the damages. So in this case, here, the example given is X raped and murdered G, who was a manager and only 30 years old. So he must restitute or restore the person of G. But in this case, G is already gone or dead because he was already murdered. So he must repay the criminal X must repay the cost of or the person of G. And it's the court who will compute that. And the manager, so his salary will be computed and his working remaining years to work. She's still 30 years old, so the age excuse me, the productive age of a person is up to 65 years old. So she has still 35 years to go. So 35 years times her salary of, let's say, 30,000 pesos per month times 12 months. So that would be the restitution or restoration amount. So X will pay that. Then reparation for damage cost. If G's family were made to pay for hospitalization, funeral expenses, then X has to pay those. And 3, liability is indemnity for consequential damages. Since there is no more G is no longer around, then X has to be made to pay for that loss, no? Loss of grief, the grief that the family of G will suffer. So these are the three civil liability in case one commits a criminal offense against a person. So what are the effects of a crime? A crime is an offense against the state because it disturbs social order. It also is an offense against the private person. So in this case, G, because it actually or directly injures or damages his right, honor, chastity, or property. Also his reputation. So crimes are, you cannot, crime is, has to be paid. Not only through imprisonment, but also payment of civil liability. And the fifth kind of juridical tie is quasi-delic. This is also known as torts under Article 1162 of the Civil Code. Now, torts are acts or omissions arising from fault or negligence which cause damage to another person. There is no pre-existing contractual relations between the parties. So, negligence is defined as a failure to observe diligence, a degree of care, precaution, and vigilance which the circumstance justly demand. So, this is danghag, no? If a person is negligent, then he shall be made to pay for loss or injury to another person. So there are different kinds of degree of diligence. Extraordinary, which is required of public transportation, and as well as banks. No? Banks are required to perform extraordinary diligence. Number two, ordinary, to act as a good father of a family. And the three is diligence agreed by the parties, or slight diligence. Now, there are different kinds of quasi-delics. First kind is called culpa aquiliana. The second is culpa contractual, and the third is culpa criminal. Example aquiliana is that Randy broke the windshield of Ed's car after carelessly throwing a baseball. So, labay baseball, igong auto, nabuak. So, in this case, Randy is liable for the damage. There's no contractual relationship. The second kind of quasi-delict is culpa contractual. Now, this time there is a contract. So, example, Flor sustained injuries when the taxi cab she was riding turned turtle. So, ningtuwad ang taxi cab. No? So, the taxi cab owner or the driver will be liable to pay for her injuries. That is culpa contractual. The third kind is culpa criminal. Example is when 18 pupils of a school died after they bought and ate cassava cake in their school canteen. So now there is death. So this is culpa criminal. No? As well as culpa contractual because there is a contract of sale. So the school canteen owner shall pay for their restoration or cost of burial and so on and so forth. Itong restitution of damages cost, this one. Reparation of damage cost, indemnity of consequential damages, restitution. So the same as a criminal offense. Is there a prescription for quasi-delicts? The answer is yes. The remedy of injured party is file a claim for indemnity or payment of damages within a period of 4 years. After the lapse of 4 years, that right to file a claim prescribes or expires.